I'm Drew Stevenson, and this is a lecture from my professional responsibility class about ABA Model Rule 5.1, which covers the responsibility of a partner or a supervisory lawyer in a law firm or some sort of law office. And so for my students, just to put this in context for the course, 5.1 to 5.7 is a group of rules about the special ethical issues that arise when lawyers work together under the same house, right? And in a firm, in a government office, as in-house counsel in a legal department at a corporation or something like that. And the question arises, when is one lawyer responsible for the ethical violations of another lawyer? Don't get this mixed up with imputation of conflicts of interest and disqualification of firms. That can relate here in the background, but that's not what we're really talking about. Let's pick something like one of your colleagues at a firm embezzles client funds or takes confidential client information and sells it to the opposing party, or something that's just clearly an ethical violation. When is a peer responsible for that? When is their supervisor responsible for that? And when can a subordinate lawyer excuse their behavior because they were doing what they were told? And especially 5.1 to 5.2 and 5.3 are kind of address this hierarchy of responsibility within a firm. And so this is 5.1, and let's look at the specifics of the rule. So A, and by the way, I have to apologize for the awkward wording of this rule. It's not mine, it's the ABA's, and also how boring this is. A partner in a law firm and a lawyer who individually or together with other lawyers possesses comparable managerial authority in a law firm. So even if we don't call them partners, if you are kind of in charge and one of the people who gets to make policy in that firm, you shall make reasonable efforts to ensure that the firm has in effect measures giving reasonable assurance that all lawyers in the firm conform to the rules of professional conduct. Well, we used reasonable twice in one sentence. What are we saying here? That basically there's an affirmative duty on the part of the people in charge of a law office to have some protocols in place to minimize ethical violations by the lawyers there, to have some supervision, to set some rules, to train new people. And as you'll see when we get into later in this rule and in 5.3, this includes lawyers who work for you and support staff. Now, this is not sort of strict liability or a zero tolerance. You're not automatically responsible for anything that happens at your firm, but instead the question is going to be whether you didn't have any safeguards in place. And as long as you take reasonable measures, you screen for conflicts, you audit the books, you check the work of new people, and make sure everybody's clear on what the rules are and so forth. If you have reasonable measures in place, then you won't be responsible for the actions of a subordinate lawyer or another lawyer at your firm. B, a lawyer having direct supervisory authority over another lawyer shall make reasonable efforts to ensure that the other lawyer conforms to the rules of professional conduct. In other words, the first section, A, is about the lawyers who are kind of in charge of the whole firm or law office or legal department and get to set policies and make the rules that everybody kind of follows day to day. This is talking about when you have a lawyer, and it could be a partner, it could be an associate who's just a senior associate and has a junior associate or a junior lawyer, a newer person assigned to them. And so if you are to use the television show Suits as an analogy, if you're Harvey and you have a Mike working for you, or you're Lewis Litt and you supervise a big bank of junior associates who work in cubicles in the library or something like that, then you could be responsible for the people that you are directly supervising. On the other hand, Harvey's probably not responsible for what an associate, Lewis's associates are doing wrong. unless Harvey, again, is the partner making it. This involves something that's a lack of firm-wide policy, but it's a different type of duty that you may have if you have a direct subordinate whose behavior you're supposed to be sort of supervising and working with. Okay, let's talk about C. A lawyer may be responsible for another lawyer's violation of the rules of professional conduct if, number one, the lawyer orders or with knowledge of the specific conduct ratifies the conduct involved. So if you tell somebody, go do this, and it's clearly an ethical violation, then they will be responsible for that, could be subject to discipline, and so could you. And or to put it another way, if you are an unethical lawyer, you can't evade disciplinary actions just by having a bunch of subordinates hiring junior lawyers to do your dirty work for you. If you are telling people to do things that violate the rules, then we can hold you responsible for that. Or if you didn't tell them to do it, but they come back to you and say, by the way, I committed this ethical violation, and you say, good job, or high fives all around, then you are ratifying the conduct, and you could therefore are kind of like an accessory after the fact, so to speak. Number two, this is going to fold together A and B. Watch. The lawyer is a partner or has comparable managerial authority in the firm in which the other lawyer practices, or has a direct supervisory authority over the other lawyer, and knows of the conduct at a time when its consequences can be avoided or mitigated, but fails to take a reasonable remedial action. And so let's assume either that you're a partner at a firm and you actually have reasonable measures in place to try to minimize ethical violations, or you have a direct subordinate and you supervise that person pretty well, but they still manage to commit an ethical violation. They embezzle client funds or lie to a court or reveal confidential information to the opposing party or something like that. Well, that so far you might not be responsible for. But if you find out about it in time to mitigate the harm or maybe avoid the harm altogether, and you don't do anything, then you could be responsible. In other words, you have an affirmative duty. Let's say you find out that one of your subordinates commits an ethical violation. They filed a frivolous pleading in the court. Well, you may still have time to notify the court and say, we need to withdraw this, or my associate did this and it was a mistake. I'm sorry. Or your subordinate destroys evidence or does something that hurts the client or the opposing party, and you could kind of rectify the situation immediately by notifying the person who's harmed, and so that either there would be no harm done or they could minimize that harm. Then you have an affirmative duty to do that. Okay, let's just talk about the comments that are likely to show up as test questions on the MPRE or my exam. Comment 1, A applies to lawyers who have managerial authority over the professional work of a firm. And so this includes members of a partnership. But even if this law firm isn't really a partnership, let's say it's a PC, a professional corporation, and we may call them the shareholders or owners or equity owners or something like that. But basically they're the people in charge. They're responsible. Or members of other associations like an LLP or something like that, who again get to set the policies and make the rules that other lawyers have to follow. And please note this one, if you have comparable managerial authority over a legal services organization, like a legal aid clinic, or a legal department, in-house counsel at a corporation, and they have a legal department with a bunch of lawyers, and you are general counsel or you're the person in charge, or you're the head of a DA's office or an attorney general's office or the city or county attorney's office, and you have other lawyers working there, but you are the person who gets to make policies for that law office, even though it's a government agency. anyone like that, even if you are a mid-level management person, if you are making the policies that other lawyers are following, then you have an affirmative duty to make good rules and have good policy. And so this means reasonable efforts. It doesn't mean doesn't mean you can guarantee that no violations occur, but you've made reasonable efforts to have internal policies and procedures designed to provide assurance that the lawyers are generally going to comply with the rules. So this could mean, by the way, training new employees and coaching people and having a manual and so forth. It can also include screening for conflicts of interest. Do you have a system for screening for conflicts? And you may remember from when we studied the conflicts of interest rules, this duty depends on the size and nature of the firm. So big firms have lots of clients and lots of lawyers, have the potential for lots and lots of conflicts. So they're going to need more elaborate screening mechanisms in place, software and staff and so forth, than a solo practitioner who has a handful of clients and can probably screen for conflicts just off the top of his or her head. Also, ways for tracking due dates, action dates by which actions have to be taken in pending matters, keeping track of that so your subordinates aren't missing deadlines. Do you have a system at the firm for helping people keep track of deadlines? Do you have a way to keep track of client funds that come in and make sure that they go into client trust accounts? And do you have training and supervision for inexperienced lawyers? Now, in a small firm of experienced lawyers, so let's say you have a firm with 3 or 4 lawyers and all of them have been practicing for a long time. Nobody there really needs anybody else's supervision. You've all been practicing for 10 years or 15 years. Informal supervision and periodic review of compliance is ordinarily sufficient. So you have some way, an annual meeting or something, or you just kind of keep your eyes open or are alert if you know that one of your colleagues is committing a lot of an ethical violation. But in a law firm, the stakes are higher, or in a practice situations in which difficult ethical problems frequently arise. Let's say you're a public defender's office and a lot of your clients end up being co-defendants in the same matter because they're co-conspirators. You might need more elaborate measures. So for example, some firms have a procedure whereby junior lawyers can make a confidential referral of an ethical problem directly to a designated senior partner or a special committee. So the ABA is basically trying to say that's the type of thing that might get you off the hook as a partner if you have a system where there's somebody who's the designated ethics expert, so people know who to talk to when they're unsure about something or have a confusing situation, and they can talk to somebody who's more experienced and very familiar with the rules, who might identify at a glance or be able to tell them what to do. In other words, you're trying to keep from an associate from having to wander the halls from office to office, seeing if anybody will take the time with them to answer a confusing question about a confusing situation. This is comment 5. Partners and lawyers with comparable authority have at least indirect responsibility for all the work being done by the firm. And while a partner or manager in charge of a particular matter ordinarily also has supervisory responsibility for the work of other firm lawyers engaged in the matter. And so I want to make a couple things clear here. So remember that if the firm gets sued for malpractice, then we have these tort ideas of things like vicarious liability or respondeat superior. And this is analogous, but it's not exactly the same. Why? Well, because there's a whole body of case law about vicarious liability and respondeat superior that doesn't control these rules. These rules are standalone rules. And the fact that a partner might have be in violation of this rule or be subject to discipline does not automatically mean that you would lose a malpractice action or be liable under malpractice, and vice versa. The fact that you are liable under malpractice, a court says, does not necessarily mean that you are subject to discipline under this rule. It could be a consideration, right? So in a malpractice action, a court can certainly give some weight to the fact that you also were disciplined by the bar for what you did. But that's not one does not automatically trigger the other. Make sure you're clear on that. They ask about that on almost every MPRE administration. The fact that you violated, that a state bar says that you violated a rule does not necessarily mean that you will be liable for malpractice to a client. And conversely, the fact that you're liable for malpractice to a client does not mean that the state bar has to or is going to discipline you for the same thing. There's a lot of factors that go into this, but it could be relevant. Now, appropriate remedial action, remember we talked about that, by a partner or managing partner depends on the immediacy of the lawyer's involvement and the seriousness of the misconduct. In other words, is the person directly involved? The more directly involved you are with whatever went wrong, the more we expect you to do something to fix it. And also, is this something very serious, or is this sort of a minor violation, and that it didn't really harm anyone that much? And so, in other words, there's going to be a whole continuum here of situations, and a state bar can look at the facts of the case. Now, this is a very important point before you give up on me with the rule 5.1. Comment 7. Apart from this rule, 5.1a, and 8.4a, a separate rule that I have another video about, a lawyer does not have disciplinary liability for the conduct of a partner, associate, or subordinate. And whether a lawyer may be liable civilly or even criminally for another lawyer's conduct is outside the scope of these rules. That's what I was just explaining. But notice this is, we specify in 5.1 and 5.2 and 5.3 when you might be subject to discipline for something another lawyer does. And if it doesn't fit under one of those rules, generally you won't be disciplined for an ethical violation by someone else. So you graduate from law school, you get a job at a firm, you're a junior associate, and another recent law school grad who works there commits an ethical violation and you had nothing to do with it, normally you will not be responsible for what they did. If you're the partner at the firm, or and you made the rules and you didn't have any type of system in place to screen for conflicts, let's say, or something like that, then maybe you would. But otherwise, if you fulfilled your obligations under this rule, you're not automatically liable for what a subordinate does. And similarly, if you are directly supervising someone, then again, that would come under 5.2b. And but you are probably not responsible if let's say you're a senior associate, not a partner, and you have a junior associate assigned to you or working second chair on your case, you might be responsible for them, but not the associate assigned to a different partner or a different senior associate. So make sure you're clear about comment 7 and the parameters. So here's a quick review question. Can a partner in a law firm be subject to discipline for violations that a subordinate lawyer commits if the firm lacks adequate protocols to ensure ethical compliance? Yes or no? This is supposed to be an easy question, and if you're really not sure about it, you should probably reread the rule and rewatch the video. And that concludes our lecture about Model Rule 5.1.